order terminates, when it goes back down. So that is now what the judge signs, and then they bring into as an addendum the OMB form. They can sign it independently as well as a second order or as an ancillary order. But I don't know if a lot of you aren't familiar with using the OMB form, but you are able to actually, when you have an income withholding order, you can take for any new employers, fill out that OMB form, sign it and send it out for a new employer. You don't have to have it signed by the judge. The way that they designed this form was so that the Department of Revenue could just send it out with a prior support order and then it go immediately in place. Well, that's not just limited to the Department of Revenue. Anyone can use the OMB form, even though it's not signed by the judge. You click the attorney box, you fill it out, you send it with the most recent support order, the most recent income deduction order, and then you can implement income withholding, even though you don't have an income deduction order directed to the brand new employer. But that's the first thing that we wanted to talk about today, was the income withholding order form has changed. It's back to the old way. So the other thing that's great about the chat is if you want to put questions, we can answer them either as we're going along or at the end. But again, Zoom 101, if you go to the chat, it's at the bottom of your screen and you hit on the button and it will show up on the right-hand side.
Completely voluntarily, it's not court mandated.
You will be able to click into the chat and get the Florida Supreme Court rule change. You'll get the OMB form, and then there's the income, a sample income deduction order that our firm put together. All right, that's income deduction order changes. Now, Chris is going to present the first important case of the year.
All right, so there's 6 cases that I actually picked since the last calendar year. The first one was Malik v. Malik, and this was the second DCA case. It was actually in a bonk hearing and essentially received from the Grigsby case. And the court said that failure to provide steps to regain the keys to the kingdom for cases where parents are limited time sharing, it's not legal error for them to not provide specific steps in the final judgment, proceeding from Grigsby. So that was a real interesting one. That happened in October. So 5 months ago that happened.
Chris, that is a big change. So, and again, there was the conflict in the districts to begin with, right?
Yeah, I think the first and the fifth were different than what we were originally following. So I think it was the fourth, third, and the second were making judges put specific steps in there.
I know a couple of years ago, I had something where I had argued to the second DCA that Grigsby, the idea that a judge has to be a mind reader and put together steps is, is an onerous burden for the judges. So that is definitely one we will want to keep. Chris has put the site in the chat. It has not reached the Southern Reporter yet, but is definitely a landmark case for the year, and you need to be familiar with it when you're doing modification in custody cases. Thanks, Chris. The next change that we have to the rules, and again, I'm going to put the change in the chat, is there were a couple changes to the appellate rules. One happened in October of 2020, and in your notice of appeal, you are obligated to note whether a motion that stays the rendition of a final order has been filed. So if you have done a motion for rehearing, motion for reconsideration, you will need to either amend your notice of appeal or include it in your notice of appeal. And everyone knows that tolls the time for filing an appeal, but sometimes one side might file it very quickly and timely, and the other side might file a request for rehearing. Other interesting thing in this specific rule change that affects family lawyers is that if you are trial counsel and you have filed a notice of appearance, or not a notice of appearance, a notice of appeal, you're automatically on the hook in the appellate case until you do something to change that. So just like in a family law case, we have the ability to do a notice of limited appearance. You can file a notice of limited appearance to file and cover your booty when you do a notice of appeal on a client's behalf to preserve the right to appeal. You can file a notice of limited appearance saying, I'm filing this notice of appeal. And that should, the other thing is you can file a motion to withdraw in the appellate court, in the trial court. When you file your notice of appeal, it goes in both places. So that's something definitely that you want to be aware of. There is a second rule change that happened. That was October 29th when those happened. There was a second appellate rule change in December of 2020. And I'm going to pop that into the chat. And again, when you click on the chat, if you want these items, just click on them. They should download to your computer download folder or wherever Zoom is. You can open it and save it wherever you like as well. The second appellate rule change that really affects us, family lawyers, is that the briefs are now calculated by word count instead of page length. Now, if you actually type it out or handwrite it, there's still a page count. But for all briefs done with a word processor and electronically filed, so I'm interested, though some people may get around this rule by saying they used a typewriter or other type of word processor. Anyway, the change is that for your initial petition or initial brief, it's 13,000 words, and it's 13,000 for the answer brief and 4,000 words for the reply brief. And just like before, it doesn't include all your preliminary pages, your table of contents, doesn't include your signature block, but it's going to be very interesting in looking at how little teeny words like citations, when you do Southern Second, if you put a period in between Southern Second, does that change your word count? It'll definitely be something that you need to be aware of. And if you're doing appellate work. Also, fonts have changed. Bye-bye to, what's our favorite font there? Times New Roman. Times New Roman is out. You're no longer able to use Times New Roman as the preferred font. It is now Arial 14-point font or Bookman Old Style 14-point. If you file documents in paper format, no staples or bindings when you send them to the appellate court. And then the certificate of service has also changed to now reflect the new, that you've met the font, new formatting, and the word counts as amended. There's also been some change, one other change in that rule, and that's the time frame for preparation and transmission of the record when you're doing a jurisdictional brief. That has been shortened from 65 days to 25 days, obviously to shorten that time frame since it's a more expedited proceeding. All right, Chris, what is our second notable case from the last year?
The second one I have on the list is Giles v. Giles, and I'll put the site in the chat. This was an alimony case where the marriage was a moderate term marriage, and it was 16 years and 11 months. And then the wife in this case argued that the trial court erred when it determined that it was a moderate term marriage under Florida law without making findings as to why. The appellate court said no and disagreed with the wife, and they said that basically said the statute doesn't require the trial court to make findings as to why it determined to the presumption of the moderate term marriage was not rebutted, and the former wife argued to the trial court that it could determine that the marriage was long-term, which it could, but again, it was not required to make findings why it did not rebut the moderate term marriage.
So we've got black letter law, 7 to 17 years is black letter law. What's interesting, of course, I always love to keep my eye out on what's going on in the legislature. There are, of course, alimony bills filed this year. There are parenting bills filed this year. We will see what happens during COVID and whether they take root. But, you know, keep an eye out. You know, you can subscribe through Online Sunshine to the family law bills and then get updates as it goes on. It's certainly worth a read as we find out when things are passed. In a month or two, we can have an update as to any new laws. But you'll want to keep an eye out because there's always interesting things happening in the legislature. Who knows if the 7 and 17 years, that's one of the bills has that changing substantially. So on to the next rule change, and that is, of course, mandatory disclosure. Boy, lots and lots of changes to mandatory disclosure. I'm going to go ahead and put in the chat the decision and talk about the changes. First of all, one of the changes that was made by the Florida Supreme Court was to provide greater specificity as to when documents must be served on the other party with regard to temporary relief. The new timeframes are when you're seeking temporary relief in an initial case or supplemental proceedings, you have to serve mandatory disclosure at least 10 days before the hearings. I am not certain about whether this rule requires that the proponent of a motion to compel must file mandatory disclosure within 10 days or a financial affidavit. But the wording is supplemental proceedings, which under the rules is anything after the entry of a final judgment when the court has ongoing jurisdiction to address matters. The responding party has to do it within 5 days. So, have there been any changes to what is required for a temporary relief hearing? Whether, and again, remember too, there isn't typically temporary relief granted as a matter of right in a modification proceeding. So, it's not as relevant, but it is if a court is going to entertain temporary relief in a modification or supplemental proceeding, it is important to know that these items are required. Okay, so the financial affidavit is one of the requirements. You have to have the complete tax returns for 3 years. And this in temporary has been modified as with the mandatory disclosure rule or the full 12.285 rule to be 3 years of tax returns, including all schedules. That's forms W-2, 1099s, K-1s. And you know, the 1098s are actually, they may not always be provided to the IRS, but that's a really good form to have because most time, and you know, the 1098 is the form that the mortgage company gives you. It'll have the interest paid, but it often has year-end balances, like starting balance for the mortgage and ending balance for the mortgage. So if you're having difficulties with your client getting certain information, the 1098 is a form that I think is very helpful as well. But it also indicates that you've got to provide with tax returns all accompanying schedules and worksheets comprising the entire tax return. Now there too, you want to really talk about what is necessary. Accountants give you, when they give you your document, they may give you 40 pages of schedules that are not actually filed with the IRS. You'll have these preliminary pages, cover pages, letters to the client. Those are not filed with the IRS. I believe the rule is limited to those documents that are filed with the IRS. Those are the necessary schedules. A lot of the other schedules are very helpful in getting information, like the ones that break out the taxpayer's income from the secondary person's income. So these are all important things to look at, but sometimes less is better. So make a decision with your clients. Are you going to give every single page that came from the accountant, or are you just going to give the information that came from the, or that is being filed with the IRS? Also important to know in the rule, and this is not new law, but if you can't get the tax returns for some reason, you can go on to irs.gov and get a tax returns transcript. That can be provided if you, actually, it says you can do it in lieu of providing the federal income tax return for purposes of a temporary relief hearing. And this is a very helpful thing. If you haven't read a tax transcript, they're very interesting. Sometimes you'll have to get a tax return and print one out to decode it, but it should give you every single line of a tax return that is completed and filed with the IRS. So it's a very nice summary and consolidated. And even if your client doesn't have access to the tax return for some reason, oh, my husband took that, he took it away, he won't give it to me, and they didn't use an accountant, you can go log on, get yourself or get the client to get a account with the IRS and get a tax return transcript fairly quickly. All right, that's temporary. I'm going to have Chris give us the next third case that's important for last year.
The next case is Webb v. Webb. This has to deal with settlement agreement enforcement. This was actually a Collier case and also a case of first impression. The former wife was seeking enforcement of the final judgment. And in this case, the former husband argued that statute of limitations barred enforcement of the final judgment, but the appellate court said no. And they ruled that when a marital settlement agreement is incorporated into a final judgment and the court entering that judgment retains jurisdiction to enforce it, the enforcement of that agreement through the final judgment is subject to statute 9511, which is a 20-year statute of limitations rather than the 5-year statutory period action on a written contract. And it was, again, it was a case of first impression. I think it was pretty creative on the attorney's part arguing that.
Excellent. All right, hang on a sec. So again, we've got, it's not real clear what's going on with the, sometimes the judiciary doesn't see the interplay. So knowing these kind of cases, having them at the ready is something that you just have to do. So that's one, definitely read, have ready when you're doing enforcement cases so that you're not foreclosed from getting the proper access to and remedies from the court. More about the changes to the mandatory disclosure form. Of course, what has happened with Rule 12.285 is that it is expanded substantially. And it's very, it's a significant burden on anyone in a family law case. And I've got some thoughts on it, but you need to know what has changed. The first thing that's important to know is that in the paragraph that talks about what you have to provide, it says you have to provide a financial affidavit. The very last sentence in that paragraph indicates as follows: you have to provide all documents supporting the income, assets, and liabilities figures entered into the financial affidavit. That must be produced. So what does that mean? That's your backup for income. That's your backup for your equitable distribution schedules. I don't believe that it is your, I don't believe you have to provide under this everything for every line on your financial affidavit, but I could be wrong. This is something we're going to have to feel out with judges, talk about. But it says all documents supporting the income, assets, and liabilities. Every single line on the financial affidavit is a potential liability, but it's not listed as a liability. It's listed as an expense. Certainly, this is something when you're talking about a moderate or a low income case, if you had to provide every single bill that they have on their financial affidavit, it's going to start getting very expensive. And in your high net worth cases as well. I mean, you've got children's expenses, you've got second family children expenses that you might put up on a financial affidavit. You might have a financial affidavit, and I've put together ones where I have the marital expenses, I have the projected post-marital expenses, and I have temporary expenses for someone who might have to go live with mom. That's a heck of a lot of information that you've got to provide if we are obligated to provide the documents to support every single one of them. You might have to be getting your mother-in-law or your mother's mortgage and rental agreement. I mean, it is so onerous. This makes it very important. I'm going to get on my soapbox. You know, we have this judicial or administrative order that we are required to get up, reach out to opposing counsel early on in cases and talk about things. This mandatory disclosure is very onerous. So I think it would behoove us to talk with opposing counsels very early on in a case once we know we have an opposing attorney and say, hey, should we agree to limit disclosure? With regard to this, it's very important to know, are you going to be seeking information on every single expense that they have? Again, my reading of the rule is that is for assets and liabilities. That's liabilities that exist or have existed. And we'll go over what that is in a minute as outlined in the rule. But that's going to be something important to talk about. I'll tell you personally, I don't want to get on the soapbox this early, I have not been filing a lot of cases. I've been trying to do them pre-suit so that I can limit this type of disclosure to the essentials, to the documents that support the assets and liabilities that need to be distributed as opposed to the expenses. Because quite often, child support is income driven. Alimony is really what's expense driven. It might be expense driven when we're talking about modifications or a deviation from child support guidelines. But if your case is not an alimony case, exchanging information with regard to expenses can be quite an expensive proposition. And I would suggest that we work with opposing counsels as to an efficient way to do these kind of things, or whether it's going to be required. And of course, know what your judges expect. All right, number 2, what else has changed? The requirement to provide the tax returns was expanded, like I said, not just for temporary relief hearings, but for all cases. You have to provide not just the tax return, but all the related schedules and the 1099s, W-2s, K-1s, every kind of document that supports the tax return has to be provided. The next thing is the tax returns. If a tax return has not been filed, of course, you should probably provide, hey, here's the extension that we filed. But you should also be giving 2 years of the documents, not just the past year, not just the pending year, 2 full years of documents if someone hasn't filed their tax returns. And again, this is real logical so that the people can ascertain incomes, as well as, you know, the 1099s, a lot of the times W-2s, 1099s provide us very important information as to cash that's flowing. When you follow the cash, you'll see and find assets. 1099s show us almost always the bank accounts. 1099s will show us if someone's in retirement status, IRAs, retirement accounts. That starts the paper trace. On W-2s, you can see if there's pensions, you can see if there's insurances. All of those little codes and boxes have meaning. What else has changed? Pay stubs are for 6 months before the filing. The changing for statements of parties, you know, that don't get pay stubs, that's changed from 3 months to 6 months as well. With regard to subsection number 6, it has been expanded. You have to provide loan applications, financial statements. Here's a new one. Guess what? I've been telling clients to provide me for years a credit report, but now we have to provide the other side with a credit report. Now, I don't know if this means you have to go and print one out, or if it means that if you've printed one out to provide it. But my belief is you should probably get your clients to provide a credit report to the other side. This is not a bad thing. This will give you all of your clients' outstanding credit cards. It'll give them a checklist. It'll give you a checklist. It'll give recent balance. And I'm not talking credit scores. Tell clients, we don't need your credit scores. We need a credit report that indicates all of their debtors that have been, reported to the credit agencies. And it is required, these things are required for 24 months. Now, here's something very onerous. It says that you have to provide financial aid forms. I don't know about you, but I've got 2 kids in college, so I do FAFSA every year. I have no idea how to print FAFSA out, but you've got to print out FAFSA and you've got to give it to someone. You've got to give it to the other side in a divorce case. Now, here I'm going to get on my soapbox. We're going to be presenting to the other side a lot of information that isn't necessarily relevant to the divorce. Yes, it gives them information. It confirms it's a way to double check the information on someone's tax return. But now we're also giving kids information, kids' incomes, kids' bank accounts. All that kind of thing is going to be in the FAFSA. And yes, I think it's probably fair game in a divorce. But as your kids get older and reach 21 and 18, they have a right too. This is a very big powder keg. You may see kids coming in and attorneys coming in for kids saying, hey, why the heck is my information being given to, some estranged parent or someone who is not even a parent, who is seeking to have a paternity test in a paternity case? Anyway, there's a big quagmire. So this is, again, why we should talk with opposing attorneys, why we should talk with each other, and be prepared for interesting and unusual objections. But third-party rights are at play here, and that is minor or adult children's information is now being required to be disclosed. Next thing, the deed section is not just about deeds. It has been expanded. It's deeds that you own or anything you have owned with anyone. It also has promissory notes that you have or have held in the last 3 years. Promissory notes and evidence regarding money owed within 24 months. It requires that you present leases. And again, leases is very broad. If you're living with grandma or mama, do you have to provide their lease? If you don't have a formal lease, what then? It also indicates too that if you are the trustee or you have anything joint with your children or for a third party, you've got to provide that as well. If you are receiving payments for leased or rental property, or you own any interest, you have to provide documentation under this rule. Next item, periodic statements for checking accounts has been expanded from 3 months to 12 months. And it has been substantially expanded again to include minor or adult dependents. So if you are writing checks for your grandparents or parents as a signer and trustee for them, you've got to provide that in a divorce case. This is an area where, again, if you are a trustee or if you have a spouse who's a trustee, they may want to say, hey, you need to make an objection for this. Surely there is ability for the other side to see it, but it is not necessarily their money. The reason we're doing these things is to ensure that they're not hiding money, but it is certainly something that you want to discuss with clients because it's got to be provided. It's got to be sent to the other side under this rule. The other major expansion is that we are back to providing checks, check registers, whether written or electronically maintained. So this kind of gets into, are we having to provide their personal software? Are we having to provide their check registers for that? Are they going to have to go into their bank account where they don't write checks anymore and provide you the detail? Yep, that's what it looks like. We have to provide. And again, if this is not a case where we have support at issue, if we're just looking to see what's the value of these accounts and do a double check to make sure that no one's taken and hidden money. But that's all about, it's one of the basic things is this is so that we don't, or that we can check for 12 months if anyone has been taking out big amounts of money. But it's got to be provided. The next one, item 6, and have we put into the rule yet? I'm going to provide you, just so you have it, providing the 12.285 list of documents in the chat. It's in Word. If this is helpful to someone, you now have the list of the documents, and you can click on it and have that available to you.
Right now, there's a question from Tony Butler in the chat. Is there, have they done an updated certificate of compliance tracking the changes from mandatory disclosure?
I believe so. And interesting, I'll be getting to it in a little bit. There has been a change in the notary on those forms. So yes, I do believe that the Supreme Court form has been updated to track it. If you go into your into the family law forms, if you can get the PDF or you can get the RTF, that'll give you the ability to grab it and put it into a Word document or put it into your case management software. I am not sure whether the West has a big case management software, but yeah, you do have to have it changed. And my belief is that if you send out and request the expanded rule, that you should do it even in cases that were in play before the change in the rule.
So I just checked, the form was updated in November of 2020, so it's updated.
Similarly, back in the chat a while, Diane Dramko asked the question, I think she's referring to the income deduction order forms, wanting to know where she can get those forms.
Well, first I put them in the chat. So if you need an income withholding form, scroll back on the chat and I put in the OMB form. And again, this is just one you can Google and get it. But OMB is like one of these governmental agencies. It's from the Federal Office of Child Support Enforcement that put it together. So it's a federal government form. You can get it through the Department of Revenue, but usually you can just get it on a Google search. But it's in the form in the chat. You can just click on it and it'll download for you. The income withholding form, there is a Florida Supreme Court form, and we've given you a form I prepared when the rule changed. So if either of those are helpful for you, they are in the chat. And again, just scroll back on the chat. Oh, and I don't know, if you logged in after the meeting started, it might not be in there. So we'll pop everything back in the chat before we close the meeting. And by the way, when the meeting closes, this chat closes. So you'll want to click on it during the meeting. What's the next item? IRA and retirement statements are also for 12 months. It's interesting that they've made this change. A lot of statements don't come out quarterly. Some are, like the year-end statements reflect 12 months. I think it's kind of overkill to have to give every single month if there isn't one. But again, that's something that we need to talk about. If you get an annual statement at the end of the year that has all 12 months, do you really need to give the rest? That's I think that's more of a preference. But it requires 12 months. So that's the new rule. Also, if you are an alternate payee receiving payments, you have to provide your statements. So that's interesting because I'm not sure if you even have access to it. So if there's a pension and pay status and you're an alternate payee in a deceased husband's pension, or a prior divorce case where you're getting someone's quadro payments, you have to provide statements for the last 12 months. I don't know if that's going to be something that you can comply with, but Ask your clients about it, talk to your clients about it. If you've got paralegals on here, these are things you need to sit and discuss with the clients. Go through each item. The next big change is we've got a new section 11 and everything else was renumbered. Virtual currency transactions have to be provided. And let me tell you, they don't give you statements. So you have to get your virtual statements. This is like Venmo, PayPal. What else, Chris? Who are the other ones that we have statements?
Bitcoin.
Bitcoins.
Yeah.
Your clients are obligated to give these statements for 12 months. I don't think these are necessarily your iTunes account, but we do have electronic liabilities now. You may have electronic statements and things. All of these are required now. Not necessarily for this one. We're talking about virtual currency transactions more in the nature of a bank account, but it's for anyone you hold an interest in. So if you are, potentially this could be very broad. If you have a PayPal account, with a community where you're the, you write the checks for the homeowners association because you're on the board, that's got to be disclosed. So again, these things are very onerous and very broad, but we've got to be very practical and move for protective orders or talk to opposing counsel and say, hey, my guy does the checkbook for the homeowners association. Do you really want me to go get the checkbook? Do I really need to provide this? The rule requires it. Life insurance policy, also 12 months of statements, not just the declarations, but you've got to provide the bills, the cash value, cash flow things. Big change, corporate interests. It is no longer 30% or greater. It is any corporate interest. Now, this is a real powder keg. If you own, half of all people get divorced. So just think about it. The big firms, big law firms, if one of the partners gets divorced, we're going to be able to get any information about that law firm or that company, even if they have one share. Is it required? Is it onerous? We've got to talk about these things with opposing counsel. Law firms, if you're involved in a case with a lawyer, they're going to come in and say, hey, no, you can't have our client's trust account, even though this lawyer can do a trust account, can sign the trust account checks. No, I can't give you the trust account. These are no-brainers that you should talk about and limit with opposing counsels. But it's required under our rules. Onerous, very onerous. I mean, real estate investment trust, there's just the obligation to provide it. I didn't make the rules. I'm just telling you what's changed. Promissory notes and documents evidencing indebtedness, 2 years. It has been expanded to 2 years, whether or not it is paid or not. So if you paid a credit card 20 months ago and closed it off, you still have to provide it. Common sense says this is going to be expensive. Oh, Alan just said, what if you own 10 shares of General Motors? You don't, I think with publicly traded companies, you just have to provide the information you get under the accounts. That's where under the first rule, you have to provide information documenting all things that you own or owe, number one. But all publicly traded companies have financial information for the taking. You just have to go to their pages and provide it, download it. Again, are we going to get that onerous? Things like stocks, you can find the value by Googling and getting what a share is worth. Are the shares encumbered? Those kind of things are easy to determine, easy to value. It's the more complicated things that are really what needs to be exchanged. Again, too, if you are a signer or if you've given your kids credit cards or you are a signer for your, or have a credit card with a dependent parent, this kind of information has to be disclosed too. And I can't say it enough. This is where common sense dictates that you may want to file a request for protective order. You may want to file an objection and just have it ready for cases where you've got third-party accounts and third parties' interests that have no bearing. You know, and judges, be ready, if there's judges on here, be ready for protective order motions and to do in-camera inspections and to say, no, you know, there has been nothing but, you know, the spouse has not put any money in or out of the account. Yes, I'll grant the protective order. There should be some good cause for these kind of things. But again, we have been in a lay all the cards down on the table for many years. And that's what the Florida Supreme Court and the family law section have decided is good for people and good for disclosure. So that's what's being required of us. Interesting too, prenups, marital agreements entered between the parties to the marriage, whether before or during the marriage. Now the new one is, and affidavits and declarations of non-paternity or judgments of disestablishment of paternity for any minor or dependent children born or conceived during the marriage. That's brand new. That's brand new. So if there's been extramarital affairs or any of these filings, you've got to ask the clients, do you have them? And then they have to be disclosed. Very interesting. Again, maybe there's been an affair. Maybe there's been an affidavit or a declaration. And it may come up. So be ready for the unexpected. One interesting and only limiting in this rule is that you used to have to provide documentation and tangible evidence regarding a party's claim that an asset or liability is non-marital. What that tangible evidence is, probably photographs, maybe, but that tangible evidence requirement has been deleted. So we'll have to ask for that in interrogatories and in trial production. Okay. Chris, I think I need a break. What's the next case on your radar?
The next case is Lbaugh v. Book, and this is a stalking injunction case. Dealt with a politician and somebody who disagreed with her views on sex offender laws online.
What
So
was happening?
here,
Yeah.
what's that?
What was happening there? A politician was online? Ooh.
No, a politician had views on sex offender laws, and then someone who disagreed with her was posting things online against that. So yeah, the respondent was making social media posts regarding the politician's reviews on the sex offender laws, made social media posts including the address of where she lived, posted photographs of her home, posted a song that contained obscene lyrics directed at her, and a cartoon depicting a tombstone with an obscene reference to the politician. However, the appellate court reversed and said that even though the posts weren't directed at her and were posted to the general public and didn't support issuance of an injunction for stalking. So, and basically for stuff like this, posting on Facebook where anyone can see it, it's not worth an injunction. However, if you send a direct message to somebody on social media, then that's a different story. And I would say, you know, Facebook, Instagram, Snapchat, TikTok, Discord, Reddit, or Tumblr would fall in that same category. The case also dealt with the First Amendment, which I haven't seen in a while in a family case. But for a politician to be involved, the Constitution protects the right of, in this case, the respondent to voice his opinions as much as it protects any citizen's right to do so. And the court essentially went on to say publicly expressing anger towards an elected official is not a basis for entry of an injunction. And as boorish, crude, and crass as the post may have been, wasn't satisfactory to meet the elements for stalking injunction.
Thank you, Chris. I have just reloaded all of the forms that we are referring to today. I still have more information, but so the last 6 items, not 6, I think 8 items, are all available you can click on them in the chat and they should open up and enable you to download them into your onto your hard drives, into your computers. Okay. The next change that we have are child support hearings. There is a notice when you have a child support hearing before a child support hearing officer. And the notice is in the rule. It talks about, should you seek to review the order upon the recommendations of the child support hearing officer, you must file a motion to vacate within 10 days. It's that notice that has to go in the notice of hearing. So, you know, it's probably got to go also in the orders, the recommended order, but now we're giving them dual notice. Interesting also in child support hearings, in the recommended order. So if there's a hearing officer or potentially a magistrate that's standing in the shoes and doing a child support hearing, in the recommended order, you have to put, if a court reporter was present, you have to put the name and address of the court reporter. If they didn't have a court reporter, you have to give the litigant the opportunity, you know, this is all being done for more for pro se litigants, but you have to indicate how a litigant can obtain a copy of the recording if it was recorded. Oh, next big change in the changes to Rule 12.285. In order to help increase self-represented litigants' access to the courts, they have deleted the notary block. Notary block. So now, what do? We swear. The language has to be there. I swear that this is true under penalties of perjury, but it is no longer notarized. The following forms have been, the notary block is deleted. Short form, family law financial affidavit. Long form, family law financial affidavit. Affidavit of diligent search, affidavit of diligent search and inquiry. Standard family law interrogatories for original and enforcement proceedings. Standard family law interrogatories for modification proceedings, and certificate of compliance with mandatory disclosure. I don't know about you, but it's off my forms. No longer do you have to have a notary. If pro ses don't have to have a notary, lawyers don't have to have a notary. Chris, do we have any more cases?
I have two more. The next one is HEPCO Data LLC versus HEPCO Medical LLC. It's not a family law case, but it's an interesting discovery case. In this case, one of the parties wanted to depose 18 witnesses, and I guess the appellee in this case, I'm not sure if they were the plaintiff or the defendant, but they said they filed a motion for protective order, basically saying that it was irrelevant to depose 18 witnesses, and the trial court agreed. So they went to the appellate court, and the appellate court said no. For material witnesses, you have to have a strong showing of good cause to prevent a deposition altogether, especially material witnesses. And the trial court didn't make that finding to rebut the suggestion that the witnesses were material witnesses. They simply said that they weren't allowing the depositions because they found they were irrelevant. However, it's also, as I'm sure many of us know, relevancy isn't a sufficient ground for a protective order. And the rule says that under 12.280, protective orders are there meant to protect a party from annoyance, embarrassment, oppression, or undue burden or expense. And at hearings, if anyone has to ever do these, the best way to do it is to either have testimony of your client or file an affidavit with the court. Otherwise, the court can't grant a protective order without competent substantial evidence, and that is another case that actually says that, and that's Bush v. Schiavo. And if you're going to have the court rely on an affidavit or have them take testimony, just make sure you're noticing the hearing as an evidentiary one. Otherwise, due process issues come into play without giving proper notice that you'll be taking testimony. So the court reversed it and quashed the order, the motion protective order, and allowed the depositions to go forward.
Discovery's broad. It's broad. So next thing about the rules that has changed, and thank you, Chris. The next thing that has changed is a big change The clerk's responsibility to redact items, to close items that are filed with the court has changed. This is a rule that happened January of this year. You know, right now, we are being required in family law cases to file our exhibits with the court. This is a big and onerous thing, and it's also a dangerous thing in my opinion. And I'm trying to work with court admin to make some changes. But after I go over the changes in the rules, and by the way, we are at 50 minutes now. I'm going to try and get through this next section. We have applied for CLE credit for this, and you will be able to get an hour of CLE credit. Christina, do we have the number for the course yet?
I don't believe we have the number for the course, but I have taken down a list of all of the attendees, and I plan on emailing you all. I just need to know last names for Catherine, Rachel, and Julia because they weren't on their name, on their plate, on their boxes. But yes, we will be getting the CLE credit. We anticipate that, and I have lists of everyone here.
Okay. And
I have, sorry, I have a mediation that starts at 1. Melanie's gonna sort of step in here or continue to be here for the remainder. Thank you.
Yeah, it shouldn't be too much longer, but thank you very much. We know that these are some really sweeping changes. And if anyone attended the course in January, it wasn't really substantially addressed. So I wanted to make sure we had a local seminar where you would get this information.
Raina, I'm sorry, I'm going to hop off too because I have mediation starting in 2 minutes. Can you, if you have new information that's not posted yet, would you mind just sending it out to everyone? Because I do have to.
This is being recorded and might should
Awesome.
be available through the Lee County Bar website.
Okay, good job. Thank you very much.
You betcha. All right. So the clerk's responsibility to redact documents has substantially changed. Judicial Administration Rule 2.420. The Supreme Court decided since media organizations in Florida reported concerns in the delay of their access to non-confidential court records, in part due to the requirement that clerk of courts independently review all new filings for confidential information, they have basically said, hey, let's take the responsibility away from the clerks of court and give it to the filers. Huh, what does that mean? That means we are now on the hot seat. It is our responsibility to file something. So my thoughts are, you file these things before you file the documents. You do your notice of confidential information first, and then you file the documents that contain the confidential information. And again, this is, the Supreme Court did this because it expressed its commitment to safeguard the public's right of access to court records. The public has a constitutional right of access to court records, and it must remain inviolate. And the Florida Supreme Court is fully committed to safeguarding this rights. So they have amended Rule 2.420 D1 to provide that in certain cases, the clerk of the court does not have an independent responsibility to identify and designate information that is confidential. It is the sole responsibility of the filer. That's us, guys. That's us, guys. The court will designate information or documents as confidential only, and there's 3 circumstances under the rule. Number 1, when they have filed a notice of confidential within the court file pursuant to 2.420 D2. And that's where you say, oh, you know, these items in the rule are confidential. Or they have filed a motion to determine confidentiality pursuant to Rule 2.420 D3. Or, and the third situation is the filing is deemed confidential by court order or the case itself is confidential by law. Now, how are we addressing it? Again, we have been required under these new COVID orders to file all of our trial and hearing exhibits in the court file. That means tax returns. That means bank statements, a lot of onerous information. I don't know if you all know this, but Westlaw and all of these, there's a lot of these major agencies that come in and sweep the court files for information. Some tips I have on that. We are trying, Kevin Carnes is watching this presentation with us, and he might weigh in a minute, but there are these information providers that come in and sweep the information on a regular basis. So some tips that I have: number one, if you can agree with opposing counsel and get the judge to sign off on an order sealing hearing exhibits in a case, that will help you. That will take care of it. You can say these documents that we're filing are sealed by our court order dated X, and then the clerk should seal it. The second thing, do your motion to determine a document confidential. The other thing these are just practical things too. Redact your documents. Don't file documents with court numbers. You know, you don't have to put the last 4 digits of an account. You can put the last 2 digits of an account. Let me just tell you, as a practical matter, the last 4 digits of a credit card account are the most important ones and help people, you know, learn the rest. The first 8 digits of a credit card are known things. They're the, you know, Visa, and then they're the institution. It's the last 8 digits that are substantial in identifying the account. And what's interesting too is we're giving to the other side everything. We're giving them a credit report. We're giving them bank statements. Please think about redacting. And when I talk about redacting, that's putting a black marker on your electronic copy, birth dates, kids' names, account numbers. These things don't have to be in the public realm. And certainly if you talk with opposing counsel, you can limit them. When you talk with the judge's office, hey, we have these really serious financial issues that we don't want to be known and out there in the public realm. Consider stipulating that documents get sealed. Until we figure out how to have a separate portal, this is going to be the law for a while. And judges are really enjoying not having to have documents and notebooks. Some like it, some don't. But it is the wave of the future. If we are obligated to file these things in a court file, I think we have an obligation to take care of safeguarding to the extent that we can this information. So those are the changes in the rules. Chris. What's the next case?
One last case, and this is, again, it's not a family law case, but it's just a general pleading case. So as I'm sure many of us know, you can't go beyond the 4 corners of a complaint when filing a motion to dismiss. And this case was a little bit interesting because it went a little bit further than that. It says when raising affirmative defenses, they must be raised in an answer. However, they shouldn't be raised in a motion to dismiss unless the allegations on the face of the complaint clearly demonstrate that the action is barred by an affirmative defense. Otherwise, considering that affirmative defense goes outside the 4 corners of the complaint. So I just wanted to throw that out there. And that is Leonzo versus WNF Law. Raina, you're muted. Raina, you're muted.
Well, it's a good thing I was muted because you were. Everyone pay attention to John Lonergan's comments. He says he's filing exhibits and filing a notice of confidential docs. And again, the clerk is only obligated to close it when the document is actually confidential under the rule. And then he's filing a motion to have it determined, and the judges are granting the motion. You know, and I think it would be a great idea to stipulate with opposing counsels early on and then file something saying notice of filing confidential exhibits. When you are filing these exhibits, try to make your notice of filing be more amorphous. Don't give these search engines the ability to say, oh, look, they filed all the tax returns of the parties. You know, you can call them, you know, document ABC. You don't have to put the last 4 digits on every single thing. You certainly don't have to identify something that you're filing as the tax return, exhibit 5, 6, 7, 8. You know, again, there are so many things we can do to protect our clients. Think about it now before you do your filing. we're in a litigious society. And when their information gets swept up and sold on the dark web, especially our more affluent clients, I would certainly hate to have the standard of care be, yes, we're obligated to file all of these things. And yes, we have an excuse, but I think we're held to a higher standard of care. And I think a lot of us, especially the board certifieds, the people who practice in this area, there are ways we can work together to exchange the information, to get it to the courts, to protect our clients from, again, personal injury lawyers suing doctors, suing businessmen. They're going to go to their divorce case and sweep it and look at the information, and they're going to seek to get these things unsealed. And that's going to present them with a lot of damning information to our clients. I know there's a lot of people that do collaborative law. I do a lot of pre-suit law. These are ideal cases for it. Well, if anyone has questions, we can put them in the chat. You can unmute. Everybody loving Zoom? All right. Well, if there are no questions.
Hey, John Lonergan, I got a question for you.
Hi, John.
Hey, early on in the IDO, you mentioned about serving the underlying child support order, but I thought I read in the rule we don't have to do that anymore.
The OMB form requires it.
Okay, just the OMB, but not the, so the judge is signing the IDO and we're just attaching the OMB, the IWO. We don't need to serve the order? Or the child support order, for example?
The underlying order itself, probably not. You can just serve the income withholding order to the new employer. I love using the OMB form though. I've got it on share screen right now. If you look at the top, it says amended one-time termination of income withholding order. This is a real helpful thing, especially if you've got a client that says, hey, my child turned 18. I should no longer pay this higher amount. I want to go to a lower amount. You can do a termination of income withholding order. You can attach, if you look down on the order, it says this must be regular. It's on its face. If you receive this document from someone other than a state, tribunal, CSE agency, or court, a copy of the underlying support order must be attached. So when you're serving this order, and again, look in the box right at the top, it says, who is serving this? The child support agency, the court, an attorney, the attorney, or a private individual or entity. We can give these to our clients. They can check the private individual or entity box. They can take and serve this on their employer and say, hey, this order says my child support terminates when this child turns 18. Here it is. My child turned 18. See the date? Terminate my income withholding. Now, you can send something in opposition saying, oh no, there's arrears, and this form provides you the ability to do that as well. Get familiar with this form. It's a very helpful form, and you don't have to have a judge sign it. You can give a prior income withholding order. You can give a prior controlling support order.
And someone else had a question about notaries on an MSA right now.
Oh, and of course, everybody knows right now you can do notarization electronically. You still have to be able to confirm, but if your client, you're meeting with your clients on Zoom and you see them notarize something that, and again, the need for notarizing things has been reduced, but yeah, you want to notarize a marital settlement agreement. You need to notarize a parenting plan. You can do it electronically. I think it's kind of a good idea while we're in COVID to use that language that this is authorized by the Supreme Court order, due to COVID. I think that's a very helpful thing because you may be in a different county than your client. What county do you put? Do you put where the notary is, or do you put where the client is? I put both. I put a slash. I put, client in wherever they are, and the lawyer is in Lee. And I think it's important to have that documented for, for the future, for our own purposes. It's always about covering it. And yes, notaries, having a notary is a protection. It isn't required. A contract isn't required to be notarized. The Supreme Court forms have a notary on a settlement agreement. It's very good to have it. In our mediations, at court mediation, there's no requirement that a notary sign. But that extra check is always an important and good thing. Also, if you have a real estate being exchanged, having the notary and two witnesses, so that it's self-authenticating in the event of it's challenged later on, someone dies. Those are important things we learned in law school, and it's important to have that when you're having a marital settlement agreement that involves real property, that involves the waiver of probate rights.
Hey, Raina?
Yeah.
Raina, it's John again. I can't remember where I read this. I think it may have been in a recent case or something, but the court, or maybe in a rule change, but the court said that MSAs must be notarized still because it's transfer of property rights. So we can't just do the affidavit form on an MSA or settlement agreement. You have to do notarization still.
And again, I for a settlement agreement involving property, child support issues, certainly it's important. So
but your point's well taken. Why a mediated settlement agreement doesn't need to be notarized, but apparently that's more in a protective setting or something,
Yeah, I think it's important to have that second safeguard of a notary, even if it's one of the attorneys or a staff member of the law office. That extra requirement just protects everybody. Any other questions or comments? Everybody doing all right? All right. Well, if that's, remember there is CLE credit for this. And Chris and I, on behalf of Chris Santaspirito and I, we thank you for joining us today.
Yeah, thank you, everybody.